Hello everyone, and thank you for tuning in to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same questions tool, and a member of our admin team will be on hand to support you. And finally, just to note, today's session is being recorded and we'll be sharing a copy with you all via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Well, good afternoon, everybody, and thank you all for finding time and joining today's webinar. My name is Max Hübner, and as Managing Director at Novagraaf in the Netherlands, I'm delighted to be your host for today. For those not familiar with our company, our success story spans more than 130 years. In brief, we are an IP consultancy firm, the leading trademark representative in the EU and beyond. And with a global reach and a local touch, we have offices and representatives around the world. We partner with many industry sectors for brands and organizations on all continents, and we are known, according to our clients, to bring their IP further. And we always want to be one step ahead. So if you have any questions about Novagraaf, please do reach out to me. I would love that, or visit our website. And having said that, let's talk about drinks. Unfortunately, we cannot have a drink because that's a bit more complicated these days. And there are more challenges which we face when it comes to drinks. So what are the current IP challenges facing the drinks industry and how do we navigate them? I'm really thrilled to introduce to you our speakers, Laura Morris, Florence Chapin, and Marlou van der Braak. And Laura will be our first speaker today. She's a trademark attorney based in the London office of Novagraaf UK, and with her 12 years experience in the field of IP and advising clients on trademark protection and enforcement, including drinks, she will sure know to excite you with her insights. Secondly, I'd like to introduce Florence Chapin. She is a trademark attorney for Novagraaf's office in the world-renowned wine city of Bordeaux. And Florence regularly works with prestigious national and international wine and spirits producers and also on their IP protection. And finally, Marlou van der Braak. Marlou is Global Legal Director, Brands, Advertising and Sponsorships at Heineken. In her role, she is responsible for IP strategy, protection and enforcement, and she supports the global commerce and global public affairs departments as well as all Heineken operating companies worldwide. And before I hand over to Laura, I have one little final remark. If you have any questions, do use the question box. So now we can begin. Laura, can I hand over to you?
Good afternoon. First, we're going to look at new products and trends in the drink industry from a UK perspective. In the UK, we've seen a significant rise in alcohol sales during the COVID-19 lockdowns. But interestingly, wider industry trends actually suggest a move towards health-conscious no alcohol and low alcohol beverages, or no-low beverages as they have become known. This can be put down to greater health awareness and the usual alcohol-free initiatives here, such as Dry January and Sober October. But there also seems to be a generational shift, with statistics showing that 1 in 3 young adults actively cutting down their alcohol consumption, and almost a quarter are choosing complete abstinence, all of which is driving the trend towards these no-low beverages. Alcohol-free spirit alternatives, such as Seedlip, Cedars and Strick, have all proved popular additions to the market, providing tasty grown-up alternatives to alcoholic spirits. Another way in which traditional alcohol brands are diversifying in the market is with ready-to-drink products. The limitations of lockdown and more outdoor socializing have led to a new demand. Sorry, I've skipped a slide. Have led to a new demand for pre-mixed ready-to-drink products that are ready to carry and easy to dispose of. A well-known English winemaker is even selling its house white in paper bottles. Although it has been around for a long time, the ready-to-drink sector has seen a 4% increase within Europe as a whole over the last year. There used to be little choice with these products, just a few standard household spirits and mixers in a can, but the sector has really expanded here into all kinds of exciting concoctions with sophisticated branding. And we see volume growth of these products is outpacing that of other beverage alcohol categories globally. Amongst this ready-to-drink category is a new trend for hard seltzers, which are essentially sparkling mineral water mixed with alcohol and sometimes fruit flavouring, very similar to Alco Pops, but with lower calorie content, so appealing to more health-conscious consumers. Even Coca-Cola has entered the game with its Topo Chico hard seltzer, with marketing targeting vegan and clean living consumers. These ready-to-drink products and hard seltzers are typically much lower in alcohol than the spirits upon which they're based. A spirit drink is itself defined as a beverage with an alcoholic strength of 15% volume or higher, but in general these pre-mixed drinks contain around 5% volume. These goods are classified as reduced alcohol products, as the alcohol content is lower than the average strength of their core ingredient. During the pandemic, home delivery of almost anything and everything became big business overnight. Staying in became the new going out, and this led to an increased demand for new and exciting ways to spend an evening at home. Those of us who enjoy an expertly mixed cocktail didn't need to miss out on great drinks, thanks to the existence of what we now call bar boxes. These boxes are delivered to your door and contain all you need to make your favourite cocktails. This new generation of cocktail delivery service allowed us to rustle up a signature tipple in the comfort of our own home, without the need for an extensive and expensive home bar. From cocktail mixes in a pouch to a full set of ingredients to make your own cocktail, the list of options in terms of the amount of effort and ingredients required is endless. So what issues do these new and booming categories of drinks products raise? Is a no alcohol drink the same as a soft drink? Is a low alcohol beer a subcategory of beer or more closely related to low alcohol alternatives to wine and spirits? Is a ready to drink product still a spirit because it's been ready mixed with a mixer? And how do you classify the contents of a bar box, where these goods are often third-party brands? These questions make us then ask what these industry changes and developments mean for brand strength, trademark registrations, and enforcement strategies. So how do we look at these goods for trademark protection and enforcement purposes? Looking at no-low products first. Retailers have always tended to group these together on supermarket shelves, separate to the bottles of spirits and wine, for example, with no-low beer and no-low wines and spirits having their own place at the end of the aisle or even around the corner. So in other words, no-low really is a subcategory of its own in the general category of alcoholic drinks. And this tallies with the way in which these drinks are marketed and consumed. They are marketed as a healthier or convenient alternative to traditional alcoholic drinks, as opposed to some new type of soft drink. That said, though, in bars and pubs, no-low drinks are often grouped with their traditional alcohol-based equivalents rather than soft drinks. For example, no and low alcohol beers are often available on tap next to the usual alcoholic beer offerings. So what does this mean in terms of trademark protection and classification? Well, as we know, low alcohol drinks generally fall under Class 33 of the NICE classification system. However, low alcohol beer falls in Class 32, as do beer-based alcopops and non-alcoholic mixers such as ginger ale, soda water, and other soft drinks. Historically, the classification of beer in Class 32 was not based on its low alcohol content, but rather on its characterization as a soft drink alternative. This is because, at the time, beers were often sold by the same companies that produced and sold soft drinks. In other words, the classification is not about the technical nature of production or the level of alcohol in the product, but rather the channels of commerce and the way the consumer perceives the drink. The choice of class will therefore depend on the intended positioning of the product. For instance, even if a product is beer-based, if the intention is to market it as a low alcohol product which is not beer, then Class 33 would likely be the proper class. Conversely, no alcohol alternatives for spirits would be registered under Class 32. From an enforcement perspective, traditionally alcoholic and non-alcoholic drinks have been considered dissimilar. While beers can be considered similar to wines, non-alcoholic beverages and energy drinks are dissimilar to alcoholic goods, as they do not originate from the same companies, do not share their method of use, and are neither in competition nor complementary with each other. However, the change in market and consumer behaviour has begun to alter the legal position. In relation to competition between alcoholic and non-alcoholic drinks, the EU IPO guidelines say that these target the same public and may be in competition. They are therefore deemed to be similar to a low degree. Whilst last year's decision in a UK case looking at no alcohol versions of drinks referenced a previous case which had held that spirits, particularly whisky, were not similar to non-alcoholic beverages, the ultimate ruling was that just as non-alcoholic beer and non-alcoholic wine in Class 32 are similar to alcoholic beer and wine, non-alcoholic gin and non-alcoholic whisky in Class 32 would be deemed similar to their alcoholic equivalents in Class 33. The decision added that the purpose of a non-alcoholic spirit is to enable those who enjoy the taste of the spirit to indulge without impeding their ability to drive or work, or to avoid conflicting with any religious issues surrounding the consumption of alcohol. On this basis, these goods must be considered similar to a medium degree. As this case confirms, products which have traditionally been seen as dissimilar are perhaps no longer so easily separated, and marketing approaches have adapted so that certain non-alcoholic beverages are now seen as a substitute for and competitor with alcoholic equivalents. As consumer demand for these no-low beverages increases, alcohol brand owners would be wise to review the scope of their registered trademark protection to ensure that it is fit for purpose. For example, where a traditional alcohol brand may previously have registered only in Class 33, they may now need to look at broadening the scope to include non-alcoholic beverages in Class 32. But it's not always as simple as that. Seeking protection in Class 32 could contravene settlement agreements that have been prepared on the basis of the historic market separation between non-alcoholic and alcoholic beverages. So brands that have previously coexisted without issue may suddenly find the risk of conflicts really increasing. And then this also affects clearance searching and watching services. Alcohol brand owners and their advisors also need to take more care in assessing the potential conflict that could arise from applications covering non-alcoholic beverages in Class 32. Previously, these perhaps weren't really considered a threat, or the cost of enforcement couldn't be justified because the commercial impact was not sufficient. But these no-low beverages have become a potentially lucrative opportunity and commercial threat to their alcoholic counterparts. Let's take the brand Seedlip as an example. It registered its EU trademark for non-alcoholic beverages, water, and flavoured waters in Class 32 in 2014. A trademark owner with a registration for gin in Class 33 may not have been concerned by this application. But Seedlip is marketed and consumed as a non-alcoholic spirit, which means it's now likely to be seen as a commercial competitor to a traditional gin brand. Moving on to ready-to-drink products, these also appear as their own distinct category on the shelf. You don't see vodkas next to their ready-to-drink versions or whiskey in theirs. These ready-to-drink products have their own section in the shop's alcohol aisle, and in many UK supermarkets, they even have their own section next to the grab-and-go soft drinks and sandwich chillers. In terms of the classification of these goods, the drinks that we used to know as alcopops fall within Class 33, and this class would also be appropriate for ready-to-drink products and hard seltzers. Brands should be aware of any limitations to their protection in terms of the nature of their goods. For example, would a registration for vodka in Class 33 extend to the marketing of that vodka within a ready-to-drink product? For these goods, it would perhaps be more appropriate to cover the broader term alcoholic beverages. Again, in some cases, there might be historic reasons why protection was limited to a specific type of alcohol, perhaps to avoid or resolve a conflict. So care should be taken when considering the extension of brand protection to encompass these goods, even where the mark has been used in a similar field for some time. In some instances, there are also potentially tricky brand positioning issues to consider around these products. For example, Some soft drinks brands are now looking to tap into the market for grown-up alcohol alternatives, such as Coca-Cola's collection of ready-to-drink mocktails, bar none, and the use of its Topo Chico water brand as the basis of a hard seltzer. In general, consumers seem to want the alcohol branding experience without the alcohol content. However, conversely, some consumers might not want to drink a product that is associated with an alcoholic version, whether for moral or religious reasons. Brands therefore need to look at the message attached to their products and decide whether they should market and promote the different products using the same or similar branding, or whether they would be better off treating them as two distinct brands and product markets. It may be some time before we return to pubs, bars and restaurants in the volume that we did before the COVID-19 crisis, but it seems unlikely that consumers' thirst for healthy alternatives and ready-to-drink products is likely to be quenched anytime soon. Whether or not they are planning to enter this growing market, brand owners in the beverage sector would be wise to rethink their approach to brand coexistence, registration and enforcement strategies. Turning to bar boxes. The question of trademark protection for these services has become increasingly important and interesting as this sector has grown. How to classify these? Often the boxes themselves are made up of already branded spirits and mixers of third parties. So the relevant classes may well be classes 30, 32 and 33, covering the ingredients themselves, but is that adequate or even correct for those companies? What about class 39 for the delivery service of these items, or entertainment and bar services in class 43? And then perhaps even a whole host of merchandising goods, such as clothing and glassware, that might be a spin-off from the core services offered. To my mind, where the goods contained within the box are not own brand, the most relevant class might ultimately be retail services in class 35, as this is the core service that's being provided. Since retail services and the goods sold themselves are deemed different, at least in opposition proceedings, brands could find themselves inadequately protected or unable to enforce against a competitor who has correctly registered in class 35, for example. Careful consideration should be given to all elements of these products when seeking trademark protection for them. We then also have to think about Brexit, because not only has the hospitality and drinks market had to deal with the impact of COVID-19, 2021 has also been the year that the UK has finally left the EU. During the transition period, the priority for trade groups, including those acting on behalf of the spirits industry, was the establishment of a free trade deal. An agreement was struck between the UK and EU, and although this provided more certainty about how the two jurisdictions would trade, issues surrounding the deal are ongoing, and it may be we do not see the full effects of this for some time. A lot of industry has been pretty much shut for a year, or exports at least reduced because of the effects of COVID. Some companies in the EU, such as wine merchants, are simply not exporting to the UK until the dust settles, and we can see how the new world will work in sending goods across the English Channel. However, some general Brexit issues and challenges that I see are as follows. Additional paperwork being required for export and import between the UK and EU, which has led to a much slower distribution of goods across the Channel and a long queue of lorries waiting. Increased costs involved in both exporting and importing alcohol, which may affect market prices, and importantly, product labelling issues, that may require the same goods to be labelled differently in order to meet both UK and EU requirements, or requiring an address in one of the EU 27 countries on the label of goods in order to meet health and safety laws. Post-Brexit discussions will therefore be key for arrangements within Europe. Industry stakeholders will be paying close attention to developments that could impact trade flows, as well as any future EU laws on alcohol ingredients labelling, which would impact the Scotch industry in particular. Brexit has also driven the need for the UK to set up its own system for the protection of geographical indications, or GIs. Broadly speaking, GIs identify food, agricultural products, wine and spirit drinks from a specific geographical area, with qualities or characteristics that are recognised for that provenance. Some well-known Scottish examples are Scotch whisky, Scottish salmon, Scotch beef and Stornoway black pudding. And of course, for the English, there are good old Cornish pasties. Like trademarks, GIs signal the quality and provenance of a product to the consumer. As a result, consumers are prepared to pay a premium price for such products compared to similar products of a generic nature. The UK government scheme came into effect on the 1st of January this year, and it protects the geographical names of food, drinks and agricultural products, including beer, cider and perry, spirit drinks, wine and aromatised wine. The new UK schemes will use 3 designations: protected designation of origin, protected geographical indication and traditional speciality guaranteed. The UK scheme is open to producers from outside the UK. These schemes may benefit UK products, and plans are in place to protect Welsh whisky using the new GI scheme. English distilleries are also hopeful for an English whisky GI and a separate definition for flavoured gin. It is hoped that a local appreciation of these goods will make it easier to protect them under the UK system than it might otherwise have been via the EU. As an extension of the GI scheme, the UK has entered into an agreement with the USA to protect certain wines and spirit drinks. These names are not protected as GIs, but are protected under a separate scheme. Over 700 wines and 2 spirits, namely bourbon whisky and Tennessee whisky, are now recognised as protected in the UK. These changes must be taken into consideration by businesses in the remaining EU countries when they import or sell into the UK. However, whilst there will be opportunities surrounding new free trade agreements with other countries and potential GIs, it is difficult to predict what the future holds. Brexit has in many ways been playing second fiddle to a global pandemic that seems to have no end in sight, and it will be some time before we see what the true effects of Brexit are on the drinks industry. The GI system for alcohol should be something to watch closely, and we will need to learn a lot from our colleagues in France, who are well accustomed to dealing with highly specific systems when it comes to wine. I will now hand over to our next speaker and my colleague Florence Chapin, who will discuss the considerations when protecting wine trademarks in France.
Thank you, Laura, and good afternoon, everyone. I'm now going to talk about the specific features of wine trademarks in France. France's history shows us wine fraud is perhaps the #1 reason the world needs wine laws. We will only be able to make a very brief overview of this very broad topic and concentrate on wine trademarks. First, let's begin with the definition of wine. Since 1973, for the OIV, the International Organization of Wine and Wine, wine is exclusively the beverage resulting from the complete or partial alcoholic fermentation of fresh grapes, whether crushed or not, or of grape must. It is specified that its alcoholic strength may not be less than 8.5% by volume. Then, just some words regarding the wine in figures. France, as the world leading exporters of wines and spirits, was the first country affected by counterfeiting. Counterfeit bottles represent just over 20% of the international wine trade. French wine production has a deeply checkered past, but that history is the reason why French wine labels are written as they are. They have the names of villages on them and not the grape varieties. It's a guarantee that all the grapes for the wine come from that village or region, and it's important for us as consumers. That's also why it's important for people who want to understand French wine labels to learn about French wine history. Here you have an illustration of a typical wine label, wine trademark. The wine trademark here is a geographic trademark referring to a geographic location, or more specifically to a vineyard. You have here Château Saint-Lô l'Hermitage. Below, you have the indication of origin, indeed Bordeaux, as the most famous one, of course. And in the middle, the figurative element, the logo, that can also be protected on its own by registering a figurative mark. At the beginning of the wine trademark, we necessarily find the vineyard, which also makes a precise definition. The vineyard is defined by the decree of May 4, 2012. This legal definition of a vineyard reads, a given entity comprised of vineyard parcels, buildings, and specific equipment, and having for vinification and wine conservation a specific individual fermenting room or one identified within a winemaking cooperation of which it is a part. In other words, a vineyard equals to vines that can be owned or leased, buildings, and a winery. Secondly, to avoid misleading consumers on the origin and the quality of wine, a regulation of 1949 provides the necessary guidelines for the use of terms such as château, clos, domaine, moulin, tour, côte, cru, or similar terms for wines to be certified appellation d'origine contrôlée, controlled designation of origin. All these terms are called regulated terms. Hence, in order to apply for a wine trademark with such terms, the wine must be certified AOC, CDO, must be derived from an existing wine growing location. The vineyard whose name is defined as a designation of wine origin must really exist. And the French court has added the condition of a cultural autonomy of the wine growers. This means that a wine is made exclusively from grapes harvested in vineyards belonging to the wine grower, and the winemaking has been carried out in the same location. This regulation has obviously an impact in practice. If a wine trademark application does not comply with these rules, its cancellation may be requested. We have in Bordeaux the famous example of the trademarks Château Figeac and Château de Figeac in Saint-Émilion, which were both used by the same vineyard and which were cancelled. The subject is quite complex, but in a simple way, the use was not legal and the cancellation of both trademarks was requested. In practice also, the main principles governing wine law have been laid down in particular by case law. Two important judgments of the Cour de Cassation, the High Court, have edicted the principle applying to trademarks, including a traditional term. These principles are the following. The holder of such a trademark must be the owner of the wine property. The holder of a trademark, including a traditional term, must also be the wine grower. What does it mean? It means that the vineyard is non-assignable without the trademark and vice versa, and the owner must be able to guarantee the harvest and vinification within the vineyard whose name is used as a trademark. Now, another consequence for the trademark is the specification of goods must be particular when you file a trademark with a traditional term. The principle is that no law requires that the origin of the wine is specified in the trademark. However, the French Trademark Office, INPI, requires to specify in the wording in Class 33 that the wines in question are PDO or PDO or PGI wines. The requirement is not the same for all traditional terms. For example, Chateau is more restrictive as it should be even more specific. We also have different requirements in the European Union. For example, when you file a trademark including the element Chateau, your wording in Class 33 must read wines that comply with the definition, condition of use of the traditional term for wine Chateau. If you do not comply with the requirements, you will face a provisional refusal. The main issues are that those specificities do not appear in the NIS classification or in the TM class reference tool. And all the trademarks offices around the world do not have the same requirements, and there is no standard wording. We are now going to see another specificity, the wine trademarks, including an indication of origin. Principles are edicted by the EU trademark regulation and the French Intellectual Property Code. These provisions namely provide that PDO and PGI may be used by any worker who sells wine in accordance with the relative protective procedural guideline. They are protected against any direct or indirect commercial use of the protected name for comparable products that do not comply with the protective procedural guideline, or to the extent that such use exploits the reputation of PDO or PGI. You cannot appropriate a PDO or include it in a trademark application, such as the following example. You have here the example of Château de Loupiac, registered in 1998 for white wines of Loupiac, controlled designation of origin from the vineyard exactly called Château de Loupiac. Today, such a trademark would be rejected because Château is a regulated term, so it's not distinctive for a trademark, and Loupiac is a designation of origin. So this trademark is not distinctive and would be rejected. You have the same consequence for Le Tertre du Médoc, because Le Tertre in the wine field is not a distinctive term, and Médoc is also an indication of origin. The great strictness of the French and European offices results from the influence of the INAO. Even the slightest reference can be enough to issue a provisional refusal. The INAO, Institut National de l'Origine et de la Qualité, is the French organization charged with regulating French agricultural products with protected designation of origin. It is controlled by the French government. It forms part of the Ministry of Agriculture. A trademark may include a PDO, but it must also contain other distinctive elements. As you can see in the example here, Domaine de Frégate AOC bundle. You have the AOC bundle, which is an AOC of southeast of France, but you also have a design of boat and the verbal elements Domaine de Frégate. Domaine is a regulated term, but Frégate is distinctive in application to wines. So this trademark complies with the conditions and can be registered. Another important illustration is the use of a PDO in other products that are not wines. We have here a recent example concerning a litigation between the Association of Champagne Producers, Comité Interprofessionnel du Vin de Champagne, CIVC, and the German supermarket chain Aldi. This litigation was about the sale by Aldi of a sorbet named Champagner Sorbet, which was violating the PDO Champagne. Basically, one of the relevant arguments held by the judgment, the sorbet did not taste like champagne. The Aldi sorbet did contain champagne, but that alone was obviously not enough to guarantee the required champagne aroma and could not then use the PDO champagne. You have another illustration for services this time and not products. The EU trademark Le Champagne, submitted in 1915, was refused for cruise ship services consisting of serving food and drinks in onboard restaurants, catering service, bar services in class 43. So it applies both to products and services. The simple, total, or partial mention of a PDO is forbidden, as we can see in the following example. You cannot use a part of an appellation. You cannot use an evocation of it. Here, Natura Emiliana is evocative of Saint-Emilion, so it was forbidden. You cannot translate a PDO. Here you have the example of Borgogna, which is the translation of Burgundy, Bourgogne. You cannot even transfer it to another country. Rioja style red wine for American wines were also forbidden. This topic necessarily leads us to question to the very recent law proclaimed by the Kremlin, which requires French champagne producers to add the word sparkling wine on the back label if they want to sell their bottles in Russia. The same law allows Russian producers of sparkling wine to use champagnskoya, the Russian word for champagne, on their own bottles. The first financial damage is that producers are unable to export champagne to the Russian market despite previous orders, as changing labels on bottles that are ready to be shipped is a real technical and financial challenge. Then, the French champagne industry asked its members to add shipment to Russia for now, stating that the name champagne is protected in over 120 countries. Protecting geographical indication is the central plank of EU trade policy, and there are risks that other countries would follow Russia's example. It's a really hot topic, as Laura previously explained, also for the UK. As for any trademarks, wine trademark must comply with trademark regulation. Then they must be viable, distinctive, and legal. Of course, you must be careful if the trademark includes PDO or PGI or specific terms. Then, in order to illustrate the brief topic, you can see that wine trademark can have many different forms. Here you have the illustration of a three-dimensional trademark with the pink bottle of Jean-Pierre Chenet, which was filed as such. You also have a classical verbal trademark, La Vie en Rose. You also have the figurative trademark, Tutiac, with the verbal name Tutiak and the design of a boat with birds. And you also have a patronymic trademark, Tétinger, which is the name of a very famous family in Champagne. Finally, regarding this regulation, you have to anticipate the filing of a wine trademark by asking if your trademark has any special features that imply legal restrictions. Thank you for listening. I will now hand over to our next speaker, Marlou van de Braak, who will talk about the pressures Heineken and beer brands alike are currently facing.
Hello, everybody. Good afternoon. I'm the Global Director, Brands, Advertising and Sponsorships at Heineken. And I'd like to introduce our company to you first. We're one of the largest brewers in the world. We have around 400, or well over 400 beer, cider and hard seltzer brands. We operate across the globe. And as you all know, our flagship brand is Heineken. But other international brands, for example, include Amstel, Desperados, Sol, Tiger, Birra Moretti, and Lagunitas. And I'd like to tell you a bit more about the key IP challenges that we face. And our most important task as an IP team is to pave the way for our business and to ensure the timely clearance and protection of our brands and our innovations wherever they are rolled out. We clear new brands in multiple countries and we make sure that all the advertising is compliant. And so we take away any hurdles that may exist in order for the business to be free to operate and to not lose valuable time in our launches. We have, for example, launched a few new innovations recently. One of them is the new hard seltzer brand, Pure Piranha. And hard seltzers, as you may know, are a very big hit in the United States, taking over a part of the beer industry, and are now making their entry into other parts of the world, including Europe. And we're now rolling this brand out in multiple countries. And of course, we need to clear issues that may exist with owners of prior Piranha brands. And one other promising category is the ultra category. That is basically beer that is low in carbs, low in calories. And we have launched Amstel Ultra. It's very successful now in Mexico. It's now being rolled out in other parts of the world, in other countries. We recently entered into a partnership with Rafael Nadal to promote the brand. But the problem trademark-wise is that in some countries, Ultra has been claimed as a trademark, where in fact it is a laudatory term, a new category name used by more brewers for low carb, low calorie beer. So that term should not be monopolized by one party. And we're in the process of invalidating some of those marks of third parties. And finally, non-alcoholic beer is increasingly popular, also because of the pandemic, but even before the pandemic, because consumers are more focused on responsible consumption, on health. And what we see is that our 0.0 propositions, including Heineken 0.0, is growing double-digit in many markets. And we're also introducing way more alcohol-free versions of other brands. And for my IP team, that means that we need to file new trademarks, we need to check new claims, like, for example, vegan, etc. Another challenge, apart from clearing those innovations, is all the infringements that take place all over the world. And we don't allow third parties to infringe our brands. We take actions against parties that sell lookalike beer products or even refill our original bottles and then close them again with fake caps. That's obviously illegal, and we take it very seriously, since counterfeit beer can be of very bad quality and dangerous to your health. We take down many online advertisements as well for fake merchandise. We see a lot of different kinds of fake merchandise, a big variety, usually low quality infringing products. And we also increasingly face new types of more harmful infringements, like scams and frauds. There are, for example, as you can see on the right-hand part of the slide, many fake job advertisements around, where people are asked to pay an amount of money and then get very disappointed if it turns out that we haven't offered that job and we don't have a job for them. Or we see, for example, fake offers of products or merchandise in which it is indicated that you have won a prize, and then when you click on such a link, malware gets installed on your phone. So that is also something that we vigorously fight against. We've also seen examples of stash cans that you can see at the left bottom of the slide. Those are cans of all kinds of beverage brands, so also Red Bull, Coca-Cola, but also Heineken, with a removable lid that you can carry, and people use it to carry drugs in and enter festival terrains or take drugs over the border, etc. So that's also something we, that's totally unacceptable. And on the dark web, we have discovered a Heineken Express store that you can see at the left top that sells drugs as well. So all those things are disturbing, are a concern to us. We are obviously more concerned about those things than about merchandise, because all the fake beer and the incorporating the Heineken brand is not good for our company, and it can affect the reputation. So we had a lot of activities around fighting infringements. Those are some of our main challenges. I was also asked to say something about the impact of the pandemic on our business, and particularly in relation to IP. What we see is that the pandemic has led to a more rapid digitization, which is a good development. At Legal, we have onboarded various legal tech solutions, and we also, for example, increasingly sign contracts digitally. The business as a whole is also digitalized. E-commerce has taken a big leap forward. Much of our advertising and sales significantly moved from on-premise, like bars, which were obviously closed for a lot of the time, to off-premise, like supermarkets, and to online. And that's, for us, brings about new business needs and therefore also new legal needs. It severely impacts our sales, this pandemic, and it still does. Many countries are still closed or partly closed. Although things are slowly improving again. So we have a focus on cost savings and smart spending as well. So we need to be more efficient. We need to negotiate better prices. We only need to do those things that matter most to us. And because alcohol sales are more restricted during the pandemic, and because people have a more focus on health, we also accelerated the innovation of non and low alcoholic beers. And we are building a more diversified beverage portfolio. And that obviously requires trademark registrations as well. So how do we achieve more with the same means? How do we try to do that? We have last year onboarded a digital trademark searching and watching solution, which allows us to do quick knockout searches online ourselves to see what brand names are available and what not in multiple countries. And that's, for us, is a way to serve the business faster than before, because we don't have to wait a few days to get results from third parties in, but we can advise on the same day. And speed is very important nowadays. That system also has good information management tools. So what we report out to our business partners internally looks very professional. In the past, we watched only our main brands, and we now can watch all of our brands, or a few hundreds of our brands at no increased cost. We monitor competition through that tool as well. And an advantage is that not only the global IP team, but all the legal counsels worldwide can also have access to that system, for which you just pay a one-off amount. In light of the fact that we encounter a lot of infringements, we're online, on the internet. We're also very happy with our online brand protection solution. For specific brands, we watch specific platforms, depending on where they are infringed most. So some brands are infringed most in Asia, others more in Americas or in Europe. We can really make it tailor-made per brand. And our provider is also able to link infringements in different countries or on different platforms to each other. since because of artificial intelligence, they can recognize email addresses, phone numbers, etc., and can link various infringements together. So for us, it's then easier to go after the source. Also, the image recognition possibilities get better all the time. So it's now also possible to not only look for the names of our brands, but also for very specific logos. And finally, we use a lot of e-signatures. That is also a result of the pandemic, because it's very cumbersome to now have to exchange physical documents and collect physical signatures. So the use of e-signatures is a big improvement. Unfortunately, some IP offices have not adopted it yet. So hopefully they'll also soon do that. We see a few nice opportunities for the future. Hopefully, and also no doubt, that trademark protection will be digitized further with less need for the exchange of physical documents, and hopefully the prosecution times can also become much shorter. For example, in Canada, it now takes about 28 months to have a trademark registered, which is for a company like ours is eternally almost, because we would really need to have to be able to register trademarks within a few months' time, and for the business to have to wait a few years is very unsatisfactory. I also expect that online brand protection will significantly improve due to improved AI, machine learning, and better image recognition. So that makes our life much easier to fight infringements. And finally, I hope, and I also think, considering the Digital Services Act, that online platforms will need to take more responsibility and will need to more actively and on their own motion monitor and take action against what happens on their platforms. After all, they have the data, they have the technological capabilities, and they have the means for this, much more so than individual brand owners. So in my view, this cannot be left to individual brand owners alone. I'll now hand it back to Laura, who will talk you through some helpful resources that are available. Thank you.
Thank you, Marlou. It's great to hear insights direct from the beer industry. Before we move on to the Q&A session, I'd like to draw your attention to a helpful resource we provide. Our monthly IP newsletter, Perspectives, is full of strategic guidance and updates on important industry developments. You can sign up to our newsletter via the website shown on this slide. If you require any IP advice following the webinar, please do not hesitate to reach out to myself, Florence, or any of our experts at Novagraph. I'll now pass back to Max to kick off our Q&A session.
Well, thank you, Florence. Sorry, everybody, there's something bugging here. So, thank you all, Laura, Florence, and Marlou, for your insights on drinks and IP and what we are facing. And just to kick off with you, Marlou, from your perspective, do you think that when you look at the beer, the wine and spirits industries, that they more or less are facing the same challenges, or do you see any differences between those?
That's a good question, Max. Thanks. Well, it's partly obviously the same. We face the same challenges from an RP perspective, and partly also different. I think that, for example, wine brands probably get less copied on merchandise, etc., than spirits and beer brands. So probably when you're in the wine industry, you need to do less online protection. Spirits, I think, on the other hand, face more counterfeiting, since spirits are typically more expensive than beers and wines. So it's also more profitable to sell fake spirits than it is to sell fake beer or wine. And beer, I think, generally typically contains less alcohol and also less calories than wine and spirits. And that, for example, during the pandemic is beneficial because, like I said before, people are more concerned about the amount of alcohol they consume. But I think for all three categories, innovation is probably focused on lower alcoholic content. Thanks.
Well, thank you for that. And please, everybody in the webinar, please join in. If you have any questions, just pop them in the question box and we can get back to you. Laura, when we look at the common law, do you think that the common law passing off will assist companies in the UK?
It can, and passing off is a useful common law tort in the UK. There are many cases where passing off has been successful where the statutes failed. I think that said, relying on passing off can be hard work. It requires an investment in terms of time and money to establish the goodwill. And that's always also not taking into account the actual litigation costs. Another issue with passing off is that, similarly to confusion, where the categories of goods are quite distinct, it can be really hard to show that the person being accused of passing off is actually making a representation, or even that representation will cause damage. So in cases where the goods directly overlap, then passing off can be more straightforward. But if, for example, we're looking at alcoholic versus non-alcoholic products, or no products, the same comparison is required. Are they similar? And again, if you have a registration for an alcoholic product, it might be more straightforward in that case to rely on the registration rather than trying to claim sufficient goodwill to rely on passing off. The reputation would also play a part in an infringement action based on trademarks, because if you have a significant reputation in your alcoholic product, then it would be hoped that that would extend you with sufficient reputation to prevent the use of the same or similar mark in respect of a non-alcoholic beverage. So both passing off and trademark infringement proceedings might be relevant. Depending on the scope of your protection and your use of the marks, then you know, a decision should be made on each case as to what's the right course of action to take. I hope that helps.
Okay, thank you for that. And sticking with you, do you think that new trademark filings include specifications to innovate 5-year use periods?
There's not really time here to look at Skykick and Monopoly, big cases in the UK, but generally the answer is no. It's always a requirement in the UK that the trademark applicant has a bona fide intention to use in the UK. And after the 2 cases that I've just mentioned, it would be expected that both competitors and the registry would keep a closer eye on refilings. To our minds, it's been the case that to simply refile the mark for the same goods and services perhaps does suggest bad faith, although it has taken some time for this to be said by any kind of court. That said, there may be a genuine reason to add some terms. So if you are considering a movement into a different product area, then and you can support that with perhaps evidence from your marketing team or internal communications, that might be sufficient to allow you some wiggle room. Alongside careful drafting with a trademark attorney, there could be some options to perhaps not only refile for the goods that you cover, but extend the scope of your protection in some ways. Simply refiling the mark with the same or an old specification is perhaps not a good idea, and so it's up to the registered owner to initiate that, and also to keep evidence of use and defend its mark once it gets to the 5-year period, to prevent it becoming vulnerable to challenges, and also to enable it to enforce it against other third parties. Thanks, Max.
Okay. Thank you for that. I'm looking to address a short question to you, because you were mentioning the influence of legal tech and how it will support you in your brand protection, more specifically online. How do you think this will look in, say, 3 years from now?
Yeah, well, it's improving all the time. So it's just easier and easier to detect infringements online. So that will only probably get better. Yeah, I cannot say how exactly it will further improve, but I would just hope that it gets easier and easier to also make arrangements with platforms like Alibaba or Facebook, etc., to take infringements down. And what you see is that that correspondence is more and more automated. So you don't need to involve lawyers everywhere, but you can just send correspondence directly to those platforms. And yeah, the quicker that goes and the quicker the infringements are taken away, the more efficient your enforcement is and the more you can tackle. And yeah, a lot of progress is made in this area. So I think there are a few big companies competing with each other and investing a lot in the right software. So yeah, can only get better.
Okay, it's going to be interesting 3 years to come. And thank you. We got one question, so I'm going to reach out to you, Laura, on this one. And it states, what are the common IP challenges faced in markets such as Southeast Asia and the cross-cultural differences? Would you reflect on that, please?
In terms of the drinks industry or in general? I mean, I think that there are a lot of issues that we face in other countries when filing from for a UK client and from a UK perspective, because systems of registration can be quite different, and enforcement strategies can be an issue. We've had one client that we've handled a lot of work in China for, and over time we've developed an efficient strategy to keep taking down and blocking registrations for marks that are problematic, but it's taken some time to develop that strategy with them. So I think there are lots of different challenges faced in various countries in Southeast Asia. The key is to be consistent and to plan with your client how you're going to approach those, because inevitably they do come up, and it's making sure that you're managing costs and also expectations on your client's part so that you can handle those as and when they arise.
Okay, thank you for your response on this one. And as I take a peek at the clock, we're reaching 14:30, which means that I think we just got about the end of our time. And I would like to thank all of the attendees for joining us in this very interesting webinar. And thank you again, Laura, Marlou, and Florence for giving us your insights, and the guys at Lexology for helping us out with all the technique and making things work, and Hannah at our office. So I wish you all a really nice afternoon. And remember, when you're going to take a glass of wine in the weekend, do check your bottle, whether it's the right one or not. Thank you again, everybody.